Let's start with a scenario that I think most of us probably know pretty well.
Okay.
You're at the office, right? And you put a few dollars into a vending machine.
Oh, I know where this is going.
Yeah. And your snack gets hopelessly wedged right against the glass. It's infuriating.
The absolute worst.
Right. But you don't scream at the metal coils.
Yeah.
And you definitely don't blame the machine's internal software.
No, you shake the glass.
Exactly. You shake the machine or, you call the 1-800 number on the side. You expect the vendor to refund your money
Right.
because the logic is really simple. The company owns the tool, so, the company owns the mistake.
Yeah, it's a completely straight line of accountability. I mean, the machine is just a piece of hardware executing a mechanical function.
Right.
If it fails, the human who plugged it in is on the hook.
But imagine if we escalate that, like significantly.
Okay.
What if we aren't talking about a vending machine dispensing chips, but an autonomous software system that's managing your company's actual finances?
That's a huge leap.
Right. So imagine it's a Friday afternoon, and this system autonomously analyzes your vendor payout history, and it just decides one of your suppliers is a financial risk.
Based on what?
Exactly, based on some hallucinated data point. And it just proactively cancels a multi-million-dollar contract without asking anyone.
Wow.
And then when the supplier threatens to sue, your company just throws its hands up and says, well, don't look at us. The algorithm did it. We can't be held responsible.
Which is wild, but that is the exact defense some organizations are, actually trying to mount right now.
Seriously.
Oh, yeah. And it is feeling spectacularly.
Well, welcome to our deep dive for today. Because we are exploring a massive, largely silent shift that is happening in the corporate world right now in April 2026.
It's everywhere.
It really is. We've officially moved past the era where AI just, drafts emails or summarizes your meeting notes. AI is actively taking independent action.
Which brings us to the core mission of our discussion today.
Right, we're exploring the accountability gap in autonomous AI.
Because we are transitioning from AI as just this, generative novelty to AI as a hard operational reality.
And the technology is vastly outrunning our governance of it.
By a mile.
Yeah.
I mean, this isn't some theoretical tech philosophy debate anymore. We are watching modern business operations and modern law just collide in real time.
And to guide us through the mechanics of this collision, we are pulling from a really compelling new article by AI thought leader Johan Steyn.
It's a great piece.
Yeah, it's called The Accountability Gap. Who owns the AI agent's mistakes?
And honestly, whether you're managing a whole team, running a business, or even just, trying to navigate your own daily workflow, the insights here are vital.
Yeah, because they highlight a fundamental breakdown in how we manage risks.
But to really understand the sheer scale of this shift, we actually need to look backwards for a second. We have to look at the golden rule of computing that governed the business world for, well, almost 50 years.
Right, the old IBM rule.
Exactly. So back in 1979, IBM published this training manual, and it contained a very clear, very strict directive.
What did it say?
It stated, a computer can never be held accountable. Therefore, a computer must never make a management decision.
Wow. I mean, that feels incredibly quaint now.
It does, right?
But you can completely see the logic. It was a hard firewall. Like, computers process data, humans make material decisions, and therefore humans hold the liability.
And it worked brilliantly for decades. But, as Steyn outlines in his research, Agentic AI has just quietly, fundamentally dismantled that IBM rule.
And we should probably be clear about what we mean by agentic here.
Good point. We aren't talking about a chatbot waiting for you to type a prompt.
Right. No humans in the loop.
Exactly. We are talking about software agents designed to take independent actions in digital environments to achieve a specific goal.
And the numbers on this are staggering. Steyn's article cites a recent Fortune report, which pulled data from Accenture and Wharton.
What did they find?
They found that nearly 75% of knowledge workers are currently using AI, and often they're relying on unsanctioned, off-the-shelf tools to execute their tasks.
75%. That's massive.
Right. And the projection for 2028 is that roughly a third of all enterprise applications will have these agentic capabilities embedded natively.
Which means the computer is, in fact, making management decisions on a daily basis.
Which completely breaks the IBM rule.
Completely. It is deciding who gets a refund. It's adjusting dynamic pricing. It's deciding which candidate's resume gets moved to the interview pile and which gets discarded.
Okay, let's unpack this. Because giving an AI agent the power to execute business decisions feels a bit like setting up an automatic bill pay on your bank account,
Sure.
but then accidentally giving the bank's algorithm permission to renegotiate your mortgage without telling you.
That's a terrifying thought.
Right. Like relying on these new AI agents feels like handing the keys to a brilliant but entirely unlicensed teenager. Sure, they can drive, but who goes to jail when they crash?
And that is the central legal tension right now.
Mhm.
And to explain the mechanics of how the legal system is viewing this, Steyn incorporates an analysis from corporate compliance insights. It comes down to a fundamental shift in how investigators look for fault.
How so?
Well, historically, when a human employee causes a massive disaster, say, a corporate fraud scandal, investigators look for intent.
Right. Did the human possess the state of mind to commit fraud?
Exactly. Did they intentionally hide documents?
Like in criminal law, they call it right, the guilty mind. You're looking for malice or willful negligence.
Precisely. But an AI agent doesn't have intent. A neural network cannot possess a state of mind.
It's just code.
Right. It doesn't want to commit fraud. It's just executing weights and biases.
Yeah.
So because of that, the legal lens has to shift entirely.
Away from intent.
Yes. Regulators are shifting their focus from intent to what the law calls duty of care.
Meaning the burden falls entirely on how the tool was managed by the human?
Yes. Duty of care is the legal obligation to avoid acts or omissions that could foreseeably harm others.
Okay.
Regulators aren't looking at the AI system to see what it wanted to do. They are looking exclusively at how the humans tested, monitored, and deployed that tool.
That makes sense.
If a bridge collapses, you don't look for the steel beam's intent, you know?
Right. You look at the engineers.
Exactly. You look at the engineer's duty of care in selecting those beams, and AI is now being treated the exact same way.
So the spotlight really swings away from the software developers and shines blindingly bright on the corporate managers and the deployment teams.
It really does.
Which brings up a pretty obvious operational problem.
Yeah.
If the IBM rule is bad, and these autonomous agents are out there driving the car, how are companies actually managing that duty of care?
Well, the terrifying answer is that in most cases, they simply aren't.
They aren't managing them at all.
Not really, no.
True.
Steyn argues that businesses are enthusiastically deploying AI agents without applying any of the standard corporate governance structures that they would, automatically require for a human being doing the exact same job.
Give me an example.
Well, think about hiring a human for procurement. You give them a clear performance framework. You establish a defined chain of accountability to a manager.
Yeah.
You have consequence management if they go over budget.
And an audit trail of their purchase orders.
Exactly. But with AI agents, companies are essentially spinning up an instance, handing it digital access, and just walking away.
Wow. And this lack of oversight creates a phenomenon that the source text calls the orphan agent.
Yes.
And we really need to talk about how this actually happens mechanically, because it sounds like science fiction, but it isn't.
No, it's very common operational failure. An orphan agent is basically an autonomous system running out there in the wild in a corporate environment with absolutely no traceable ties to a responsible human being.
How does that even happen?
Okay, say a mid-level marketing manager uses a corporate credit card to spin up an AI agent via an API.
Okay.
And its job is to autonomously buy digital ad space based on market trends.
Makes sense.
It works great. But then, 6 months later, that manager quits and leaves the company. Yeah. The agent is still running. It is still buying ad space. But no one currently on the organizational chart knows how it was configured, what its spending limits are, or even how to turn it off.
It's orphaned.
It is orphaned.
And Steyn gives a really grounded example of why this is so dangerous. He specifically looks at the audit profession.
Right.
He points out that the immediate danger of an orphan agent isn't necessarily that the AI goes rogue, like in a movie.
Right.
The danger is human complacency. It's that human auditors will just stop interrogating the outputs because they don't truly understand how the AI arrived at its conclusions.
It is the psychological phenomenon known as automation bias.
Right.
When humans are presented with a clean, beautifully formatted spreadsheet or a highly confident summary generated by a machine, our brains naturally just want to trust it.
We just assume the underlying math is objective.
Exactly. But these AI agents aren't just doing arithmetic. They are making probabilistic contextual judgments.
Right.
If a human auditor doesn't understand the probabilistic reasoning the AI used, they can't accurately audit its output. They just end up rubber stamping it.
But wait, if I'm listening to this as a department head, my immediate thought is if my human employees are just blindly trusting the AI because they don't understand the output, Aren't we just trading human error for much faster, highly scalable machine error?
Yes.
I mean, why am I even paying for this technology if my team still has to constantly monitor it?
But what's fascinating here is that the perceived efficiency of these systems is often a complete illusion.
Really?
Yeah. Steyn cites a major study from Workday that was published in January 2026.
What did they find?
They analyzed corporate workflows and found that up to 40% of the time that AI supposedly saved a company in a given workflow was actually lost later on. The time that AI supposedly saved a company in a given workflow was actually lost later on.
40%. That is a massive operational tax.
It is. And the reason is because users had to go back into the system, untangle the autonomous decisions, double-check the logic, and then fix the hallucinations those agents made.
It's like hiring a junior assistant who works at the speed of light but constantly makes typos.
Exactly.
And you have to spend half your week fixing them. You haven't actually saved time, you've just shifted your job from doing the work to babysitting the machine.
And this massive failure of internal governance is exactly why the legal system is stepping in.
Because companies are failing to self-regulate.
Right. Companies are bleeding time fixing orphan agents, and real harms are occurring.
Biased hiring practices, contractual breaches, financial losses.
All of it. So the courts are being forced to fill this governance vacuum.
Now, as we get into how regions like California and the EU are legislating this, we do want to remind you, the listener, that we aren't taking a stance on whether these specific regulations are good or bad for business innovation.
Right. We're just analyzing the reality.
Our goal here is purely to break down what Johan Steyn's research outlines regarding the shifting legal reality on the ground.
And that reality is that the era of using the AI as a scapegoat is completely over. The defense of the AI did it is dead.
So what are the actual laws doing?
Well, the source material highlights California's AB 316, which took effect in January 2026. According to legal analysis from Baker Botts, cited in the text, this legislation explicitly forecloses the black box defense.
Meaning if an AI agent you deployed causes financial or physical harm, you can no longer stand in front of a judge and argue, hey, we didn't know how the algorithm works, so we shouldn't be liable.
Exactly. The defense of we lacked control over its autonomous decisions is legally invalid now.
Wow.
And we see similar movements globally. The European Union's AI Act has its rules for high-risk systems taking effect very soon, in August 2026.
And what do those rules mandate?
They mandate incredibly strict human oversight. If you deploy an agent in a high-risk category like critical infrastructure or employment, you have to prove you have a human actively monitoring the system who has the power to override it instantly.
And the legal precedents are already piling up. Sven points to a landmark federal case from May 2025, Mobley v. Workday.
Yes, a very important case.
This involved alleged algorithmic hiring bias, and the federal judge allowed the case to proceed by applying what is called agency theory.
Right, and agency theory is a really fundamental legal principle. It basically states that if you hire someone to act on your behalf, an agent, you, as the principal, are on the hook for their actions.
Okay, so like an employer and an employee.
Exactly. If you hire a bouncer for your bar and the bouncer assaults a patron, the patron sues the bar, not just the bouncer.
So the court essentially ruled that the AI screening tool was acting as an agent of the employer.
Yes.
Therefore, the organization deploying the tool bears primary responsibility for the discrimination.
That's right.
And a firm called Damon Legal observed this case and noted that courts are establishing a very specific liability trifecta.
Right. 3 key questions.
They're going to look for 3 things. Who put the agent into production? Who configured its specific permissions? And who pointed it at the customers?
And if your company did those 3 things, well, your company owns the outcome.
Here's where it gets really interesting, though. Because if the deployer is fully liable, surely corporate lawyers are trying to build firewalls around this, right?
Oh, of course.
I mean, you can't sue a piece of code. And if courts are blocking the "we didn't know" excuse, have companies tried arguing that the AI itself is essentially a digital employee or a separate legal entity to avoid getting sued?
They absolutely are attempting that strategy. Steyn highlights an analysis from the law firm Squire Patton Boggs.
Okay.
They note that as human instruction gets further and further removed from the AI's final output, assigning direct human responsibility gets genuinely complicated.
Because it's so autonomous.
Right. Because of that mechanical difficulty, Some legal theorists and corporations have seriously suggested treating AI systems as separate legal persons.
Which isn't totally unprecedented in law. I mean, a corporation is treated as a separate legal person, right? To shield its owners from direct liability.
That is the exact model they are trying to replicate here. If the AI is its own legal entity, then the AI absorbs the liability. You sue the algorithm, not the parent company that deployed it.
But is it working?
No. The courts have roundly and repeatedly rejected this framework. Judges are refusing to let companies create liability heat shields out of code.
So the blame bounces right back to the humans.
It bounces right off the machine and sticks to the humans who bought it and turned it on.
So if we look at the landscape we've mapped out here, we have agents making autonomous decisions. We have a massive lack of internal corporate governance creating orphan agents.
Right.
And we have a legal system that is aggressively piercing any attempt to shield the deployer.
Yes.
So what does this all mean for the listener's company, their bosses, or their own workflow today?
Well, the sweeping mandate from courts and regulators can really be distilled down to 3 words. Liability follows control.
Liability follows control.
Exactly. If your organization controls the system's deployment, you own the system's mistakes.
And Steyn makes a really crucial point for anyone in leadership listening to this. AI governance is no longer just an IT issue.
Not at all.
It is not a technical glitch you leave to the software engineers to patch. It is a fundamental board-level risk.
And financial regulators are already enforcing this view. The research points out that FINRA, the Financial Industry Regulatory Authority, has issued guidance dictating that board-level oversight of AI must be fully operational by the end of 2026.
That's huge.
It is. This isn't just about having some loose policy document in a drawer. FINRA requires a designated human executive who holds explicit accountability for the risk profile of these AI models.
But Steyn also brings a really unique global perspective to this issue, drawn from his work in South Africa.
Yes, his work there is fascinating.
He served on a working group contributing to South Africa's national AI strategy, and he highlights a severe geographic divide in how this liability is being managed.
Right, because while California and the EU are building these highly structured, strict legislative frameworks, regions like South Africa and broadly across the African continent currently exist in a regulatory vacuum.
Meaning there are no comprehensive local AI-specific laws on the books yet.
Exactly. But Steyn is very explicit about what that means. If you are operating in one of those regions, that regulatory vacuum is not a safe harbor.
Doesn't mean you have a free pass to deploy reckless agents.
Far from it. A lack of AI-specific legislation just means that harm can accumulate unchecked.
Plus, international businesses are still subject to other laws, right?
Yes, if you are a business operating internationally from South Africa, you are still bound by those strict EU and US laws when interacting with their citizens. And secondly, and probably more importantly, even if you operate purely locally, you are still exposed to massive civil and reputational risk.
Because of the common law.
Exactly. And we should probably define how common law works here.
Yeah, please do.
Common law relies on historical legal precedents rather than written statutes. So even without a shiny new AI act, if your autonomous agent hallucinates and breaches a contract or causes financial harm to a consumer, a judge doesn't need a new tech law to penalize you.
They just use the old laws.
Exactly. They will simply apply centuries-old principles of negligence and liability. The legal system will still find a way to make you pay for a breach of duty of care.
So for you listening, whether you are a CIO, a mid-level manager, or just a small business owner, the actionable takeaway is pretty clear.
Very clear.
For CIOs, it means building an architecture of accountability right now, today.
You need rigorous audit trails.
Right. If an agent executes a trade or sends a legal notice, you need to be able to show exactly what data it used, what thresholds it was operating under, and what humans signed off on its permissions, because if it fails, it's a management failure, not a tech glitch.
This raises an important question that every listener should be asking their leadership.
What's that?
Are we treating AI governance as a later problem? Because businesses that view governance as just some compliance task they will get to eventually, well, they're accumulating massive, unquantified liability with every passing minute that those agents are running.
Johan Steyn's core argument is really a necessary wake-up call.
It is.
The technology does not come with accountability built in. You cannot download an ethical framework via an API.
No, you can't.
That is and remains a uniquely human responsibility.
And the organizations that recognize this fact today and actually build the human governance structures to match their technology are going to be the only ones left standing when the inevitable wave of autonomous legal battles begins.
Which brings us to a final, slightly provocative thought to leave you with.
Okay.
We know from the data we discussed earlier that Gartner projects by 2028, agentic AI will make up to 15% of day-to-day enterprise decisions entirely autonomously.
Right, a massive volume of corporate action.
Exactly, with zero human intervention. But consider this scenario. What happens when your company's AI agent is tasked with negotiating a software contract, and it ends up negotiating directly with the vendor company's AI agent?
With zero humans in the loop.
Zero humors.
Well,
What happens when an autonomous agent makes a highly costly contractual mistake that was actually triggered by the hallucination of the other autonomous agent?
oh wow.
When agents start interacting with agents and errors compound at the speed of light, how on earth does the legal system untangle an entirely machine-to-machine web of liability?
That is the frontier we are rushing toward blindfolded. And one thing is certain, when the agents start suing the agents, the humans are still going to be the ones paying the legal fees.
It definitely changes how you look at the automated systems running in the background of your office right now. We really encourage you to interrogate the AI tools you are using in your own workflows today. Ask the hard, mechanical questions about who owns the output before that output owns you. Thanks for exploring this complex landscape with us, and we'll catch you on the next deep dive.